Chicago, are you ready?
You're ready.
You're ready.
I will call the meeting of the Illinois State Board of Elections. It's Tuesday, October 21st. It's 10 a.m. And if you would all rise, we'll start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Amy, we'll have a roll call, please.
Ms. Ballard-Croft?
Present.
Ms. Craig?
Present.
Ms. Genovese?
Here.
Ms. McCrory?
Here.
Mr. Brett?
Here.
Ms. Watson?
Here.
Vice Chair Turbin?
Here.
Chair Donahue?
Here. On page 1 through 5 in your agenda are the minutes. Do I have a motion to approve?
I move to approve the minutes.
Second.
It has been moved and seconded. Amy, roll call, please.
Ms. Ballard-Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Next on the agenda is our report by our general counsel, campaign disclosure settlement offers. Jordan?
Yes, good morning.
Good morning.
Good morning. There it is. Okay, sorry. First time with this microphone. Good morning. So we will go ahead and start with the report of the General Counsel. First, there are 5 settlement offers on the agenda today. We have appearances from 3 of those parties. We'll go ahead and start with those first. The first matter is SBE versus Will County Democratic Central Committee. I do have record of an appearance on file. Is there a representation? Yes.
Yes.
So you may stand, but first I will read my recommendation, and following my recommendation, you may comment.
Okay.
Oh, that works too. Okay, yeah. You can come up here and sit by me. That way we can have you on camera, and our board members in Springfield will be able to see you as well.
Sounds good.
Okay.
Is it a green light on the ceiling?
Preference.
Very good. So in this matter, the committee is offering $4,500 to settle $9,000 in civil penalties assessed for the delinquent filing of 4 Schedule A1 reports. These reports were reported between 36 and 55 days late during the 4th quarter of 2024. These were the committee's 6th, 7th, 8th, and 9th violations. While the committee's offer of $4,500 is 50% of the fine total, the committee is not low dollar, and the offer is inconsistent with the board's preferred balance and receipt ratios, as the offer is just over 18% of the fine balance ratio and just under 18.5% of the receipt ratio. Therefore, I do recommend rejecting the settlement offer. And now, if you could state your name.
Yes.
If you could state your name and spell it for the court reporter, and then go ahead and make any remarks.
Matthew Welch, W-E-L-C-H. So this PAC is currently low dollar. It doesn't raise money on a consistent basis. They are sincerely apologetic that they missed these dates. They've implemented internal procedures to avoid this in the future, but they are offering, they don't have the assets right now to meet what's being recommended. They believe the $4,500 is a reasonable offer, but we're willing to entertain other considerations.
Thank you, Mr. Welch. Yes, member Craig. Tom Newman, I'm going to assume you're up in Chicago. Could you tell me what their ending balance in their report is right now, please?
Here we go, Green. As of the last quarter, it was a little under $42,000.
Any other questions? Do I have a motion? Member, use the
Do we know what
microphone,
that-
please, Catherine.
I'm gonna say, do we know what the amount is that would meet our criteria, that they would be able to make an offer on today or accept?
Sure. So to be consistent with the preferred balance and fine ratios, those preferred balance and fine ratios are 50%.
Right,
They're currently standing at 18%.
right.
I do not have the ability to do that math.
I always say I went to law school because I can't do math, so
Me too.
I'm fine with that.
However, Mr. Newman, is that a figure that you would be able to?
And I'm not trying to put you on the spot, I'm just wondering if we have that ability to do that. If not, we can take a vote.
We really don't, because it's,
Well,
the ratios we're talking about are comparing the amount of the fine to their average receipts over the last year and their average balance. And based on that, they've had enough activity that they wouldn't normally qualify.
Right. But if they talk to you, or you would be able to do that math for them or with them to
No,
figure that out, or no?
it's not a question. The math won't change, because again, it's based on what money they've taken in and on what their balance has been over the past year, that compared to the fine.
Right.
So it is unlikely then, if to get the balance and receipt ratios to that preferred 50%, at that point, we are either very close to, at, or exceeding the $9,000
I figured.
fine penalty.
That's why I'm asking the question, because I figured at 18%, we're nowhere near
Yes.
what we need to be as far as the 9,000 is concerned. Okay, that's all I have. Thank you.
Mr. Welch, do you have a oh, go ahead.
Madam Chair,
Yes.
my question, I just want to be clear. The representative said that they are low dollar, and the general counsel's report says that they are not low dollar.
Yes,
So
Jordan?
I'd like a response from the respondent.
Yeah, so I apologize. I thought the balance was lower, but they traditionally spend down as we're coming up to a cycle, and that's why I was stating that.
Right.
And the last balance then is $45,000. Is that from you, Mr. Newman?
Just under 42,000. So that would have been as of September 30th.
And what is your title with the committee?
Counsel to the committee.
Oh, so you're an attorney.
Yes.
So are you authorized to pay the entire $9,000 this morning?
I am not. Right now, I have authorization for the 4,500.
Thank you.
Is there any other discussion? Do I have a motion?
Make a motion to accept the recommendation of the general counsel and deny the settlement offer.
Second that motion.
It's been moved and seconded. Amy, roll call, please.
Ms. Malloy-Croft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese? Yeah. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Jordan, on 2A2? Oh,
Yeah,
no, you want to go to 2A4 with appearances? Is that what you wanted?
Yes, please. If we may do matter 2A4, which is the SBE versus Friends of Tiffany N. Brooks. The committee is represented by Mr. Giaconetti. And as he comes up and gets settled, I will go ahead and read my recommendation, if that's okay. There we go. So here, the committee is offering $3,750 to settle $6,500 in civil penalties assessed for the delinquent filings of the March, June, September, and December 2022 quarterly reports. The offer exceeds the 50% threshold and does comport with the board's preferred balance and receipt ratios. For these reasons, I do recommend accepting the settlement offer. However, I would like to note that this committee was administratively closed in January of 2024. Though since that closure, the committee has filed all of its missing reports as well as the final report. The reports indicate that the committee was effectively closed on September 30th, 2024, and as a result, no additional penalties are likely to be assessed against this committee. Campaign disclosure does indicate that the candidate does appear to intend to run in the near future, and records indicate that a successor committee has been initiated. Mr. Jackson?
I appreciate the recommendation of General Counsel. Thank you for the opportunity, members of the board, to speak a few minutes on this. This is one of those situations in which circumstances ran ahead of the candidate and her committee. They had competent accounting representation at the time that the initial reports were filed. Unfortunately, that gentleman fell ill. His sickness was more serious than anybody realized. He passed away. Notices were sent along the way, and the candidate herself had a series of cascading events of close friends, relatives of people who passed away, and anybody who's been in a situation like that knows it kind of consumed your life and time escaped her. But in any event, she found herself counsel. We've remedied the situation. The final reports have been filed. The committee is zeroed out. I would point out two factors. 77.5% of the assets of this campaign committee were either in-kind contributions or loans from the candidate. So this is a very low budget operation, and she only repaid herself back a portion of what was owed. The balance, according to the original D1, was donated to charity, to a church. So I would ask your favorable acceptance of the offer.
Is there discussion? Is there discussion? Questions? Do I have a motion?
So moved to accept the hearing officer's.
Second.
It has been moved and seconded. Amy, roll call, please.
Ms. Malloy-Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right.
Thank you.
Jordan, 2A5.
Yes, 2A5, SBE versus Citizens for Victoria.
We have in Chicago appearance.
Yes, we do. And
By Victoria. So you go ahead and do your thing, Jordan, and then we'll hear from Victoria.
I will. This committee is offering $250 to settle $1,450 in civil penalties assessed for the delinquent filing of their September and December 2024 quarterly reports. The offer comports with the board's preferred balance and receipt ratios, but it does fall short of the preferred 50% threshold. However, the committee is considered low dollar with an average ending receipt of $2,057. So I do recommend accepting the settlement offer.
All right.
If you could state your name for the court reporter.
Yes, Victoria, state your name and say what you will.
Good morning. My name is Victoria Van, and listen, you all in full vulnerability. This is my first time running, and I really was not expecting to get elected. I did it because my son was being bullied, and I decided to step up and run and represent. So that's why I did it. Had no idea anything about a committee or anything like that. It was literally my first time. This was a learning experience. It will not happen again. I've definitely learned, okay? I just thank you for your time, and I hope that you accept the offer.
Thank you, Victoria. Do I have a motion? Or are there any questions? Do I have a motion?
Make a
Move
motion to
to-
accept this recommendation of the general counsel and accept the settlement offer. Second?
It has been moved and seconded. Amy, roll call, please.
Ms. Bella Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Jordan,
Yes, Chair.
we have an appearance here in Springfield for 2A6.
Okay, perfect. We can go ahead and take that next.
Sure. Mr. Knapp?
You can come on.
You can put him right here. Okay. Go ahead, Jordan.
Okay. So agenda item 2A6 is SBE versus the Committee to Elect Randy Knapp. Here, the committee is returning with an updated settlement offer. The committee is offering $500 to settle $3,620 in civil penalties assessed for the delinquent filing of the September 2024 quarterly report and 3 Schedule A1 reports during that same quarter. This is a low-dollar, closed committee, and the offer does comport with the board's preferred balance and receipt ratios. For these reasons, I recommend accepting the settlement offer of $500.
All right. With us in Springfield is Mr. Knapp. If you'd like to speak, sir.
Good morning. Thank you for letting me speak today. My offer has been accepted. I don't really know if I need to make a comment, but thanks for giving me the opportunity, and I appreciate your judgment and the offer.
Thank you, sir. Any questions? Do I have a motion, please?
So moved to accept the report of the general counsel.
Second. It's been moved and seconded. Amy, roll call, please.
Ms. Bella Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you very much.
Thank you.
Is there anybody out there for that?
No.
Okay. All right. Jordan?
Yes, if we could move back up to agenda item 2A2. I do not have a record for an appearance on this matter from a representative of Friends of Marcus Herbert for sheriff. Is there anyone in the Chicago office on this matter? Anyone in Springfield?
No.
Okay.
You want-
Here, I will go ahead and read my recommendation very briefly. My recommendation here is to accept the settlement offer as of $750 to settle assessed penalties of $1,500 for the delinquent filing of the December 2024 quarterly report.
Move to accept the general counsel's recommendation and accept the settlement offer.
Second?
It's been moved and seconded. Amy, roll call, please.
Ms. Bella Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right. And 2A3 has been postponed. Is that correct?
Correct. That has been continued to November in light of illness of the representative of the committee. So our next section would then be appeals of campaign disclosure fines, where the hearing officer's recommendation was to grant the appeal. Agenda item number 7, which is the SBE versus Illinois Valley Federation of Labor, AFL-CIO PAC. Is there
Any
anyone
discussion?
is there anyone in either Chicago or Springfield on this matter?
No one in Springfield.
Very good. In this matter, the hearing officer recommends, and I concur, to grant the appeal as the contribution at issue here, when properly categorized, does not necessitate the filing of Schedule A1 reports under Section 9-10C. Here, the committee has amended its quarterly report to properly itemize the aggregate contribution at issue here. And so if the board does adopt this recommendation, the stay that was lifted from a previously assessed penalty will be placed back on that previously assessed penalty, and the committee will not have any balance due and owing.
Thank you, Jordan. Do we have a motion, please?
Motion to accept the report of the hearing officer and general counsel.
Second. It's been moved and seconded. Roll call, Amy?
Ms. Ballarcroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Jordan?
Thank you, Chair. The next group of the next group of items are appeals of campaign disclosure fines, where the hearing officer recommendation is to deny the appeal. I have an appearance from one of the matters here, Friends of Don Harmon for State Senate. Are there any other appearances for the candidate or for the committees listed in agenda items 8 through 14 in either the Springfield or Chicago offices?
We have none here.
Okay, we will go ahead and proceed with agenda item number 10 then, SBE versus Friends of Don Harmon for State Senate.
All right, Jordan, you want to proceed?
Very good, I will. Here, the committee is appealing the assessment of civil penalties resulting from the committee's acceptance of contributions in excess of contribution limits identified in Section 9-8.5B of the Election Code. However, before diving into the merits of the appeal, there is a preliminary matter of a petition to intervene. I'm going to ask that the board first rule on this petition before proceeding to the merits of the committee's appeal. With regard to the petition to intervene, Nick Beatty, represented by counsel Jeffrey Schwat, SCHWAT, petitioned to intervene in this matter. The petitioner seeks to intervene as a member of the media with an interest in the case, and particularly identified that interest as seeking judicial review in the event that the board does not reach a majority consensus on the merits of this matter. The hearing officer recommends, and I concur, that the petition to intervene be denied, as petitioner Beatty has not identified the conditions permitted under Section 125.130A required for a party to intervene. If it is appropriate, I would ask that a member of the board move to adopt this recommendation on the petition to intervene or deny this.
Do I have a motion?
I move to adopt the general counsel and hearing officer's recommendation to deny the petition to intervene by the petitioner.
Second. It's been moved and seconded.
I'm sorry.
Catherine, okay. Roll call, Amy.
Ms. Ballarcroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you. Before discussing the arguments and recommendations at issue here, I want to acknowledge that all of the arguments rely heavily on the statutory language of Sections 9-8.5B, 9-8.5H, and 9-1.92 of the Election Code. All of these statutes are quoted verbatim in the parties' briefs, in the hearing officer recommendation, and all of those materials are included in your board materials and the public agenda on this matter. As such, I do not intend to quote these sections in making this recommendation, but I do acknowledge that the parties' briefs and the hearing officer recommendation are a part of the record in this matter, and that I have considered them strongly in making this recommendation. Here, the committee is appealing the assessment of $9,846,475 under Section 9-8.5J of the Election Code. penalties resulting from the committee's acceptance of contributions in excess of the contribution limitations identified within Section 9-8.5B. These penalties may be broken down into two amounts. First, the penalty assessed at $5,797,425, which is 150% of the overage amount, with the first violation reduced to 10% and the second violation reduced to 50% under Section 125.425E2 of the Board's Administrative Rules. And second, the escheatment amount of $4,049,050, the amount of contributions exceeding the contribution limits, which is to escheat to the state's general revenue fund under Section 9-8.5J. The amounts, the penalty and escheatment amounts respectively, are identified based on the Board's interpretation of the expiration of the committee's notice of self-funding. The committee argues that the Board has misinterpreted this expiration date, and as such, both the penalty and escheatment amounts were assessed in error. In fact, the committee argues the contribution limits should not have reattached because Senator Harman's notice of self-funding should be based on the office's election cycle. Here, the election cycle for the 39th legislative district for which the senator is a candidate, and not the day of the next general election cycle, the date that was applied by the Board here. Without those limits reattaching then, the committee did not accept contributions in excess of the limitation. The facts of this matter are largely not in dispute. The committee, Friends of Don Harman for State Senate, is a candidate committee organized to support Senator Don Harman's candidacy for state senator from the 39th legislative district. Senator Harman contributed more than $100,000 to his candidate committee on January 13th, 2023. As a result of this contribution, a notice of self-funding was published on January 17th, 2023. As a result of this notice, campaign contribution limits for candidates for state senator from the 39th legislative district were lifted as of January 2023. Senator Harman has a history of self-funding consistent with the Board's interpretation without having accepted excess contributions. So, the question on appeal is when and whether the contribution caps have reattached. The Board's assessment process here was to acknowledge that Senator Harman permissibly lifted the contribution limits for himself and all other candidates for the office of state senator for the 39th legislative district as of his January 13th, 2023 contribution, because that contribution was made within 12 months preceding an election. Here, that election was the 2023 consolidated election. And the contribution was within 12 months of both the consolidated primary and the consolidated election. The Board's assessment process followed the definition of an election cycle as provided in 9-1.92, which identifies the culmination of an election cycle as either the day of the next general primary election or December 31st following a general election. Here, the Board's assessment process identified the culmination of the self-funding period as the former, the day of the next general primary, which was March 19th, 2024. The committee, in its appeal, asserts that this interpretation is inconsistent with the statutory language of 9-8.5H because subparagraph H lifts the contribution limits for all candidates for that office, and the only election at which a candidate impacted by Senator Harman's self-funding, e.g., a candidate for the office of state senator from the 39th legislative district, could possibly seek election is the March 2026 general primary. The committee also argues that the Board's interpretation is inconsistent with the intent of Section 9-8.5H because it leads to the absurd result of the contribution caps being lifted during a time frame when it is impractical that other non-incumbent candidates for the office of legislative office would be running and fundraising for that office. I did say the word office an awful lot there. Thank you for bearing with me. Both counsel for Respondent Committee and the board's general counsel drafted and filed briefs in support of their respective interpretations. Oral arguments were held before the hearing officer, with only Respondent Committee offering oral arguments. And the hearing officer issued a recommendation that, 1, the board find that the Respondent Committee failed to establish by a preponderance of the evidence that the board's assessment was in error because the plain language of Section 9-8.5 supports the board's interpretation. And 2, Respondent Committee has an established history of acknowledging and abiding by the board's interpretation of the duration of self-funding that, while incongruent with the office's election cycle, is consistent with the plain language of 9-8.5H and 9-1.92. I have read the report of the hearing officer, and I concur with the recommended findings of fact, with the recommended findings of fact and conclusions of law contained therein. It is my opinion and my recommendation that the appeal be denied because respondents' statutory interpretation and policy arguments may be interesting, but they do not establish by a preponderance of the evidence that the board's practice of identifying the culmination of a notice of self-funding consistent with the plain language of both sections 9-8.5H and 9-1.92 is in error. And these provisions do not contain such ambiguity that the board, in its ministerial capacity, can deviate from the plain language presented therein and extend the duration and the effect of the notice of self-funding beyond either the day of the next general primary or December 31st of the general election following the contribution of self-funding to a committee which lifts the contribution limitations. As a final matter, Respondent Committee argues that the penalty amounts assessed are unconstitutional both under the federal Constitution and under the Illinois Constitution. Respondent Committee agrees, and the hearing officer recommends as well. And so do I concur that the board does not have the jurisdiction to determine, assess, or evaluate the constitutionality of the penalty provisions of the election code generally and those of Section 9-8.5J. Thank you very much. I will turn this over to Mike Casper, representative for Respondent Committee.
Thank you, Ms. Andrew. Michael Casper, K-A-S-P-E-R, for the Respondent Committee. I would urge the board, Madam Chair, members of the committee, thank you for your time. I would urge the board to reject the hearing officer's recommendation. Ms. Andrew, in her presentation, cited a number of, or pointed to a number of statutory provisions that relate to this, but this really boils down to the interpretation of one sentence. That sentence is the fourth sentence in Section 9-8.5H of the Election Code. And my principal quarrel with Ms. Andrews' recommendation and the staff's recommendation in describing the position that I am attempting to take here, Ms. Andrews used the word cycle twice relating to election cycle. The word cycle does not appear in that sentence, the sentence that I'm citing. This is what the statute says. This is the sentence that the election code contains regarding the removal of the contribution limitation. This appears, for those of you in Springfield, if you can't see it, this is on page 5 of my submission.
Okay, I'll catch up.
If a public official, Public Senator Harmon, nobody disputes is a public official, contributes more than $100,000, then the contribution caps are removed. Contribution caps for whom? All candidates for that office. All candidates for that office. So a person cannot self-fund an election cycle. you self-fund your election. Senator Harmon is self-funding his election. That occurs in 2026. The word cycle does not appear in this sentence. So why are we talking about removing 4 cycles when this refers to candidates for office? You can only be a candidate for office at an election at which it appears on the ballot. My principal quarrel with the hearing officer's recommendation, this is on page 11 of her report. She says that the hearing officer says that what's missing from this sentence is, quote, absent in the statute is any reference to an election at which the candidate is running. Absent from the statute is any reference to the election at which the candidate is running. What does the word "that" mean? That office does not appear on the ballot until March of 2026. There is no election other than that election that the word "that" in that sentence can apply to. So I take this, that's my principal exception, is that the staff and the hearing officer focus on the word election cycle. The limits are applied by election cycle. We all agree with that. The limits can be removed by self-funding. We all agree with that. Senator Harmon removed the limitations by making a self-funding contribution. The question is, when does that last until? Does that last until the election to which they made a self-funding contribution? Or does that last to some other point? It's my contention that the reference to candidates for that office means just what it says. That office. When does that office appear on the ballot? March of 26. That's when the limitations were removed. The board and hearing officer's interpretation instead turns the contribution limitations into this. Well, not that. This. This looks like a roller coaster ride at Six Flags. Here are the contribution limitations in 2022 into 2023 for this office. Then they literally go to the sky. But then halfway to the election, they drop back down again. It's just like the eagle at Six Flags, right? Right? And then there's a bump because there's the inflation adjustment that you do every 2 years, right? So they go up a little bit more. This is what you need an accountant and a lawyer just to run for the Illinois Senate. That's crazy. That is not what the legislature intended to do. What the legislature intended to do by creating 2 election cycles for the Senate was to equalize the treatment of House candidates and Senate candidates. That was the intention of the statute all along. So there's 2 cycles, an election cycle every 2 years. So under the interpretation of the hearing officer, when a candidate for the House of Representatives self-funds, how long does that last? You know what? You know what the answer is? Until that election. But for the Senate, oh no, not so fast. Maybe it does if you're in a 2-year term, but if you're in a 4-year term, it doesn't last until that election. So it treats House and Senate candidates differently. And that is not the intention of that, and it's not the intention of that because if that's the result, it's a dumb result. This is dumb, right? So Senator Harmon, the Senate president, can raise an unlimited amount of money. He could amass $50 million. And then the limitations get removed 2 years before his election. The contribution limitations get reattached under the hearing officer's interpretation 2 years before the election. Good luck running against him in the primary election. That is completely unfair. Nobody is thinking about running in the 2026 election prior to 2024 except him. So he has this incredible advantage. And that is in Ms. Jordan and, I'm sorry, Ms. Andrew, and you probably get that a lot.
All the time.
And the hearing officer, they said, well, that's an interesting point, Mike. Oh, yeah, you know why? Because it's an absurd outcome. It is unfair. And this statute was designed to eliminate unfairness, not to enhance unfairness. So for that reason, we think that the statute supports the interpretation of the fact that Senator Harmon's self-funding contribution removed the contribution limitations for all candidates, including him, for that office, and he's a candidate for that office when he made that self-funding contribution. When he made the self-funding contribution in January of 2023, he was a candidate for his office. He's a candidate for his office here. He's a candidate for office here, for here, and here. Nothing's changed between when he made that self-funding contribution and today. He's a candidate for that office. His status hasn't changed. So by making that self-funding contribution, he remained, it removed the contributions for as long as he was a candidate for that office. When is he no longer going to be a candidate for the office? After the election to that office. I just completely am at a loss to understand why the hearing officer ruled differently. What the hearing officer said was, endorsed this notion that the limitations, once they're removed, they remain removed only till the end of that cycle, that election cycle. But the word election cycle does not appear in the sentence that controls what's happening here. The next sentence in the statute does contain the word cycle. Okay, so what's that all about? The next sentence is the one that says, if you self-fund before a primary election and you're nominated, then the limitations remain off until for the next election cycle, right? That's what it says, the next, okay. That didn't happen to Senator Harmon in 2024 because he wasn't on the ballot in the primary of 2024. The statute says, if a public official or candidate self-funds during a primary election cycle and that public official is nominated, then the limitations remain off through the next cycle. Not election, cycle. Okay. So that didn't apply to Senator Harmon in 2024 because he wasn't nominated by his party in 2024. Why not? Because the office he's seeking wasn't on the ballot in 2024. This sentence will apply to Senator Harmon next year. If he runs in the primary election and he's nominated, then the caps will remain off. So why does the word cycle appear in this sentence but not in the previous sentence? You know why? Because the cycle for a primary is coterminous with the election. It ends on election day. The cycle for a general election is not coterminous with the election. It continues to the end of the calendar year. So if you use the word election rather than cycle, there would be an incongruity because the caps would remain off only until election day rather than through the end of the cycle at the end of the year. So that's the reason why cycle had to appear in this last sentence, or the second to last sentence, of 9-8.5H, but not in the previous one. So for that reason, I believe that the statute supports Senator Harmon's contributions and that the caps, once removed for candidates for that office, remain off until he's no longer a candidate for that office, which happens on the day of the election. So briefly, just for purposes of preserve, I also pointed out that at a minimum, the contribution limitations were removed until the end of the general election cycle in 2024. That's an alternative argument that we put forward. And that's described in my paper on page 12. The board has a regulation that says, in describing this self-funding provision, this is 100.75K3, for candidates not seeking nomination in a primary election. That sounds real familiar to Don Harmon in March of 2024, right? That's him. Then it goes on to say that then relates, if you don't appear on the election, it relates to the general election ensuing. So under either interpretation, the contribution limitations did not reattach prior to the 2024 primary election. And so for that reason, we think that the hearing officer's report is incorrect. I think that the plain language of the statute it should be interpreted exactly what it says. When a candidate self-funds, they remove the contribution limitation for all candidates for that office. And they remain off as long as that candidate is a candidate for that office. That happens in March of 2026. And I will also for purposes of preserving the record, $9 million is an absurd amount of funds under any circumstances, and I believe that would render the assessment unconstitutional under both the federal and state constitution. I'm happy to take any questions. Thank you for your time.
Thank you, Mr. Casper. Questions? Comments?
Sir, I will move to reject the hearing officer's recommendation and grant the appeal.
I second that.
Is there a discussion? Discussion? It has been moved and seconded to reject the recommendations of the hearing officer. Amy, roll call.
Ms. Ballarcroft?
Yes. Yes.
Ms. Craig?
No.
Ms. Genovese?
Yes.
Ms. McCrory?
No.
Mr. Brett?
No.
That was a no, correct?
That was a no.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
No.
4-4. Failed.
Thank you for your time, Madam Chairman.
I would, on a 4-4 vote, members are required to make a brief statement regarding the basis for their vote. If you'd like to start, Member Ballard-Croft.
Okay. I do not find that this statute is ambiguous. I think the plain language of section 9.8.5H references elections, not election cycles. The legislator could have limited the duration to an election cycle, as they did throughout the section 9-8.5, including in section 9.8.5B, but they did not do so in section H. I find that this is an intentional distinction by the legislator to distinguish elections from election cycles. Section 9.8.5H states that once a candidate self-funds above $100,000, all candidates for that office may accept contributions beyond the limit, and you remain a candidate for that office until the election for that office, in this case, March 17th, 2026. Finally, I think that any other interpretation creates unfair and inconsistent outcomes. It undermines legislative intent to level the playing field between wealthy incumbents and less resourced challengers.
Thank you.
Should we just do Chicago and then we can just bring?
I think that would be most efficient, yes. Member Brett?
First of all, I adopt the reasoning and rationale of our general counsel and their recommendation as part of my rationale. I further would like to state for the record that over the course of my term in this office on the board, I've consistently stated that we ought to hold large organizations and committees to the same standards as smaller organizations, and therefore, I think that there is no reason to treat this committee any differently than we would any other committee merely because of the value of the money at stake. So I would supplement the record that way as a further rationale. We have a consistent practice that we've adapted over the years. The record shows that in the course of the committee's existence, it has consistently complied with that practice, and this was one instance where it deviated from the practice and therefore received the fine.
Member McCrory? I do adopt the recommendation of the General Counsel and the hearing officer, and here's why. I read statutes on a daily basis, some of the most boring information you can possibly read, and I'm sure everybody's eyes roll back in their head when they read these statutes. But what I have always been, and I will continue to be, is a strict constructionalist when I'm reading these statutes. With regard to Section H, 9.85 Section H, you read a statute as a whole. You don't bifurcate it. You don't dissect it. You read it as a whole, and reading this as a whole, it interprets it as an election cycle. Now, when we talk about election cycles, we are talking specifically in this statute, it gives you a roadmap for the election cycle. And therefore, I will stick with that roadmap for the election cycle. If we did anything different, if we adopted the committee's interpretation of this, it would create chaos. And for each election cycle run, or each election that we have, every 2 years, every 4 years, there would create chaos not only for the candidate to interpret that, but it would create chaos for our organization to try and determine whether somebody is in violation or in compliance with that. And so therefore, I will stick with the strict construction of the election cycle definition, and I reject the committee's argument.
Thank you. In Springfield, whomever would like to start?
I'll start. Fine. I reject the recommendation of the hearing officer, and we're just kind of repeating the same argument. However, I do not believe that the plain language of Section 9.85H. I do think that it says election, not election cycles. So I don't think there's plain language in that section, so there is room and it is ambiguous. And again, I think if we use election cycles for self-funding, it takes, the unfairness is completely in place, right? The whole point of election, the whole statute here is to make the playing field equal, right? So that, we don't have individuals receiving unlimited funds every cycle. However, when self-funding comes in, the whole point of this is to lift these and make it an even playing field for every candidate. And I do believe the argument is well stated, that how is a candidate 2 years, 4 years in advance even thinking about running for this Senate spot? And an argument that I really, I thought about when reading this is that, when Mr. Casper put in there that you would self-fund, and then at the next cycle, you would just pay yourself back, and then you would self-fund again. And that cycle goes over and over again. And I do not see how that legislative intent meant for that to happen. To just continuously repay yourself back and self-fund. It doesn't make any sense to me. So with that, I do reject the recommendation of the hearing.
I very simply adopt the recommendation of the hearing officer and the general counsel, and I agree with members Brett and McCrory. I have nothing more to add. I echo what they said.
I reject the report of the hearing officer.
Great.
Can you hear me now? Can everybody hear me?
Yes, I can.
Okay. I also reject the committee hearing officer's report, and I echo what Member Ballard brought and what Member Genevieve said on why we did. Say that again.
Oh, nothing. Thank you, Vice Chair Turbin. Chair Donahue?
Yes, I'm coming. Just getting our microphones organized here. Thank you. I to support the recommendations of the general counsel and hearing officer, reflect the things that were mentioned by Member Brett and Member McCrory. But I would add that 5 times this committee has funded and made a deliberate action to put the $101,000 into their account to self-fund 5 times prior to this. And I think that shows that there was an understanding of the statute as recommended by the hearing officer, or a pretty serious mistake was made because they were notified by the state board. And that's where I stand. And if there's anything else, Jordan?
Just Member Watson.
Oh,
the basis for
sorry, Member Watson.
I am
Cassandra.
so sorry. That was my fault.
Goodness. You were not overlooked. I apologize.
I agree with the interpretation provided by Member Jennifer Ballard Croft, as well as the respondent's interpretation provided by Attorney Michael Casper. Interpretations are just that. They are individual interpretations. But adding words to statutes, I do not agree with that. I do not agree in ignoring words that are in statutes. And in my, considerable excess of 40 years of election law, all words in election law statute are there for a reason. Therefore, I cannot ignore 9-8.5H when I read candidate, quote unquote, and then for that office.
All right, thank you, Member Watson. Jordan, anything further you need?
Well, I have some additional questions now that we've completed our presentation. And it's 4-4. Jordan, would there be any initiation of any ballot forfeiture action based on the outstanding monies due and owing based in this case?
Thank you, Member Watson. So at this point, with a 4-4 vote from the board, there has not been an action by the board. Therefore, the appeal, the penalties, both the assessment and the escheatment amount, are due and owing to the board. Because the penalties have been assessed.
It's my belief that it takes 5 votes to find a violation of the election.
Correct.
So you can't assess until you find a violation.
And the assessment was found, the assessment was assessed, and you had requested to appeal that assessment. Yes, we will. And so the interpretation now, and the action now that follows, will be that the penalties will be due and owing to be paid within 30 days of the board order. At that point, until and unless the order of the board is appealed under Section 9-22 of the Election Code, penalties will be due and owing.
Mr. Casper, I assume that you are planning to then appeal.
Use the microphone, please. Jennifer, please use the microphone.
Sure. I asked Mr. Casper if he then intended to appeal.
I disagree with Ms. Andrews' interpretation that the board just found that Senator Harmon failed to find that Senator Harmon violated the election code. So how can he owe $10 million when you haven't found he violated the code?
I don't agree with that interpretation.
I'm not surprised.
You're splitting hairs.
But
we may know finding.
It was a no, it was.
Yeah, but it takes a vote of 5 to find a violation of the code. That's to take any
It's a
action.
vote of 5 to find that he has not violated.
No, I
I
disagree.
mean, I know.
This was an appeal, correct? So the board already found that there was a violation, and now the committee is seeking to appeal that, and then there has not been a majority to overturn and grant the appeal.
Well, I don't know when we agreed that there was a violation. I have not been present at any meeting where the board found that there was a violation. Now, a division in the agency may have made a finding, but I was not present, and I want the record to be clear. I was not present at any board hearing where this board found that there had been a violation.
I concur with Member Watson.
Well,
Or just tell us when we met and found that there was a violation.
I don't think that's a question to be answered. I think we're here today, and this is the vote we're sitting on, and we're trying to interpret what the next steps are.
Well, I'm glad that that's your interpretation. The statement by Mr. Vreck was that the board has already found a violation. I just want to know, for the record, which is obviously going to be in the Circuit Court of Cook County, when did we meet and find that there was a violation? I would like that date, please.
I think the State Board of Elections found a violation, and there cannot be an appeal unless there was a violation. That's our process. Now, it was appealed, and we're voting on the appeal of that violation right now.
So
that is the process.
In other words, there is no date on which the board actually met in open session.
You're misinterpreting.
This is an appeal of an assessment. This is an appeal of an assessment made by a division. That's what this is.
And that's what our process is. And the appeal is based on a violation found by the agency, and we are to rule on an appeal. That is the process.
I think everyone understands what I meant. So, in other words, Mr. Who's the head of the disclosure division? What's his, Mr. Harmon, what's your name? Mr. Newman. So in other words, you will initiate a ballot forfeiture action based on the outstanding monies due and owing in this case. Is that correct?
Yes, Member Watson, that is correct.
So if I may, I think that this is a critical matter. And I think there is significant disagreement as to what the board has or has not done. I would move to stay the enforcement of any penalties pending the appeal.
Second that motion.
But, so we need to know today whether or not there will be an appeal in order to make that vote.
Yes.
There will be an appeal.
Sure.
I would also like to clarify something if I could. Oh, sorry about that. What I would like to say is that possibly the confusion is coming from so many in this situation that there's an alleged violation is what we've all been hearing. Today was the first time that I remember that we ever voted on anything and went to a forfeit tie. But alleged is the word I get. We have a motion before.
there is a motion.
I'll second.
There's a motion to move, that's been moved and seconded to stay. Would you restate it, Jennifer, in the microphone, please?
Yes, I moved that we
stay the enforcement of the penalties pending the appeal.
Do I have a question?
We have a question.
Do we have the authority to do that? I know this is a bit unprecedented.
Certainly.
And if you need a minute, take a minute. But I want to know if we actually have the authority to stay in enforcement.
The penalty provisions here are governed by section 9-8.5J. 9-8.5J contemplates two distinct penalties. One, an escheatment amount for overages of the contribution limits, which is, the statutory language is that amount shall escheat to the general revenue fund. The second penalty action, or the second penalty contemplated under subparagraph J, is penalties assessed by the State Board of Elections. The language of 9.8.5J says that the board shall assess penalties not to exceed 150% of the contribution overages. So the language of J requires that we assess penalties, and it requires that there is a ceiling on what those penalties will be. However, it does not establish a timeline for that. The board, similarly, the language of subparagraph J does not contemplate a timeline or give the state board enforcement of and for any monies that are to escheat to the general revenue fund. So the process for this would be to issue a final order requiring action be taken by the committee for balances due and owing within a timeline. Our typical timeline for that is 30 days from the date of the board order. However, any enforcement for the escheatment would be done not by the state board, but that would be a matter that would be referred to the Attorney General's office. So at this point, we would be contemplating a split here. Now, the extent to which we could stay that during the pendency of the appeal, it's unclear. I don't think that I do not think we don't have the authority, and we can, as an agency, establish timelines, and there have been instances where we have established timelines for a repayment of civil penalties that are due and owing. I think we do maintain that authority, certainly, for any penalties that are assessed by the state board, here regarding the $5 million in fines. However, the extent to which the state board can establish a timeline regarding the escheatment, that is less clear. But what I'm very sorry, remember, but we certainly can memorialize the intent of the board here clearly, that it is the intent of the board to contemplate a stay of one or both penalties during the pendency of the appeal, and then a party aggrieved by that certainly then may take that order up for judicial review under the terms of section 9-22.
Yeah, and if I may, I agree with Ms. Andrews that there must be action by the board. A final order must be entered. You need 5 votes to get to a final order. And in the absence of 5 votes, then there's deadlock. And that's why the statute says that any action of the board requires 5 affirmative votes. So there has to be affirmative votes to find a violation.
The reason why
if I had the code, I'd find it.
As you can appreciate, Mr. Casper, the reason why I'm vetting this is because we are deadlocked, right? And I want the adjudication of this to be fair. And so I want to make sure that we're taking the correct steps and not, for lack of a better term, putting you in a trick bag, right? And again, I want to be fair. We definitely, you know, on this board, we do not agree on this matter for our own reasons, and for some of us for our own legal minds. But I want to be able to either issue an order or stay in order for you to be able to vet this more clearly for yourself.
And if I may speak to the process generally, where the board assesses penalties, be they penalties that we've already discussed here for delinquent filings of Schedule A1 reports, delinquent filings of quarterly reports, delinquent filings of Schedule or D1 forms, organizing a committee, or be they penalties associated with accepting contribution in violation of contribution limits. The board has delegates that authority to its staff members, the Division of Campaign Disclosure. Campaign Disclosure produces an assessment letter indicating what the violation is, how much the assessment amount is, pursuant to rules that we have adopted in our administrative code and or pursuant to any limitations or details that are identified in statute. Following that, the language in that assessment letter, and I'm going to quote the letter that was sent to the respondent committee here, provides the total amount will be imposed with the issuance of a final order after the 30-day appeal period has expired unless an appeal is filed. This amount must be paid within 30 days of the issuance of the board order. And so here what we have, the board has, and there typically in the event that the board grants the appeal, the final order is that there is no penalty assessed. If the board rejects the appeal, the final order is assessed. Now, in this matter, the appeal, the motion of the board was to reject the recommendation and reject the appeal. It was 4-4. So there's been no action by the board here. However, I do believe that the assessment, the authority that was delegated to assess these penalties does remain, and this may be an issue that we could allow the vote on the appeal to stand today, and then we could come back to research the effect of the 4-4 on the assessment and that process generally, and to the extent that Mr. Casper is interested to represent his client's interest in and advises of his opinion, and then we could do the same.
Well, and also, I want to be cognizant of the fact that if we push this down the road and we've got a ballot forfeiture hanging in the wings, that might not be the best remedy for us to kick the can.
Yeah, I would.
And I'm taking the seriousness of that into account when I'm having this conversation with you.
I appreciate that. If I could direct your attention to section 1A-7. Sorry, I took your book. This is on page 64 of this blue binder book.
The code.
1A-7.
We're almost there.
What are books? No, that's good. I got it.
64.
Okay.
The second sentence of section 1A-7 says, 5 members of the board are necessary to constitute a quorum, and 5 votes are necessary for any action of the board to become effective. It seems to me a $10 million fine is an action by the board.
But when you look at the case note,
I don't know if I agree with you on that.
I have a question for the general counsel.
Jack, look at the case notes down below where it says deadlock.
Can you read that to us, Jack?
Yes, it says in the deadlock, according to the case notes,
Illinois State Board of Elections is entitled to deadlock on issues where it cannot obtain the 5 votes necessary to take any action. The board's deadlock is not required to be broken in favor of proceeding on a complaint. And then it cites Illinois Campaign for Political Reform versus Illinois State Board of Elections, 388 Ill App 3rd 517 from 2019, or 2009.
That's right, and what that gets to is which is not the case here.
Right.
Where there's a complainant. If a complainant alleges that a committee violated the code, and the committee and the board deadlocks 4-4, then there's no action assessing a penalty against that committee, but the complainant can still appeal, because what they sought from the board, a finding of violation, was lacking because it was a 4-4 vote.
Is your position, or this might be a question to you, Mr. Casper, on your behalf, the client or general counsel, when the board issues a notice of a violation to a committee and they receive it, and that happens as the regular process of the board staff notifying committees and individuals that there's been a violation of campaign finance law. So they notice.
I think we need to use the word board and agency.
Okay. When the agency sends that notification and someone receives it and says, oh my gosh, I have a violation, and they pay it, is it your position that they actually have not had a violation because at that time there has not been a vote by 5 members of the board letting them know that there has been a violation?
Well, if they're not contesting the assessment, then I think they have a right to contest it. And if they don't contest it, if they contest it and there's a 4-4 vote, there's not a finding of a violation, because 1A7 says it takes 5 votes for any action.
Okay. What if they don't contest it and the fine continues and now they're in a ballot forfeiture? There's never been a board action, right? There's never been a five members of the board have voted in favor of.
I may.
Thank you.
If I may. Every month we have the agenda item to. I want
to. But it's based on
assessments and
the
board
violation.
orders.
It would be based on a violation, though.
Right, sure. The board assesses the violations that are uncontested. But they're not due and owing until you act on what the staff did. So here, in this instance, what I think Ms. Andrew is suggesting is that Mr. Newman and his folks can just assess a penalty. And unless there's 5 votes to overturn that, then it goes into effect. And that's not the law. The law says it takes 5 votes for any action of the board. In assessing a penalty, you haven't accepted Mr. Newman's assessment either. So you have to have it takes 5 votes to have an action. And in the absence of 5 votes either way, then there is no action.
And because there isn't any action, there shouldn't be any initiation of any ballot forfeiture. Because there was no action. That's my point. Mr. Newman does not have the ability nor the authority to initiate ballot forfeiture action based upon what Mr. Brett just read under deadlock. So he doesn't have that authority, because we can't give him that authority, because we have taken no action.
I don't necessarily have a problem with what we're contemplating.
Catherine, take the mic.
I don't necessarily have a problem with what we're contemplating. I have a problem with the fact that we have to do it properly, and the procedure has to be there. And I don't think this, 5.1A-7 or even the deadlock case actually speaks to that. I don't think it tells us what our next steps are.
If I may offer a suggestion, and I may offer to limit the board order here as a result of the action of the board today, the 4-4 tie, the no action. Limit that the board order to that determination on the merits of the appeal. And then if we may, continue the remaining question of whether or not to assess penalties to the November meeting. So we would have an initial board order narrowly tailored to the board's determination regarding the appeal as presented and as recommended by the hearing officer and myself. Then that would be it. Any additional language or orders relating to the assessments, penalties due and owing, that contemplation, we can continue that to the November 18th meeting of the board.
And will that take care of the board forfeiture issue? Or I mean, the ballot forfeiture issue?
Ballot forfeiture, Section 9-30, does not come into play until and unless there are balances due and owing at the time that the ballot is certified in January. Typically, we look to shore up, finish out any appeals at the December meeting to allow committees whose appeals were not granted sufficient time before January. I am in no way, shape, or form recommending that we kick this matter beyond December. And ideally, it would be November, but at that point, I'm just going to suggest that we do a narrowly tailored board order to the appeal here and then allow the issue of balances due and owing to be continued to November.
Thank you. I just want to understand that timeline.
Yeah. And then just I want to confirm that you will write, your recommendation gives the committee a sufficient final order that they could then appeal if they wanted to court.
And that was my other concern.
I want them to have jurisdiction to get answer on the statutory construction issue.
I think it takes an affirmative vote of 5 members to assess the penalty.
We're not talking about.
Well, to answer your question, I can't appeal until there's an assessment. My client, as of today, doesn't owe any money because you haven't acted.
The trigger was the board order, the final order.
Yeah,
Not the assessment.
but there won't be a final order imposing a penalty.
The order that would be drafted today would not be a final order. It would be an order on the appeal. So it would be similar and akin to, but very distinct from, an order on a complaint following closed preliminary hearing. At that point, the board orders that the issue move forward. So what we're ordering here in this very limited non-final order, essentially any appellate process that would take place following this limited board order on the appeal, there would not be any penalties due and owing identified in that final order. The extent to which the respondent committee would be interested or wish to appeal, it would not be a final order, so it would not be appealable at that time. The appeal would be initiated then in following the final order that would be issued in November. So this would be a limited
Jordan, let me just understand what you're saying. Because I just want to be absolutely clear on what you're saying. For example, this matter coming before this court on this matter of a deadlock or something, of that kind. I mean, and then saying, what are you going to say? Because everything that has been said recently in the hearing is that this board, through its authorization process, will still be able to initiate a ballot forfeiture action. based on the outstanding monies due and owing, notwithstanding the fact and taking into consideration the fact that your non-final order is not going to address it. Your non-final order sounds as if it is going to be silent on that issue. And we have already discussed the fact that, silence is not going to do it. A judicial review is going to start with the fact that you don't have, a quorum for an order. They're going to start with the beginning of the Illinois Election Code. The board has an order if there are 5 votes. That's where they're going to start.
I think at this point, there are too many questions to be answered right now.
So
I think at this point, there are too many questions. So my recommendation, Member Watson, is that everybody does their homework and we bring in case law, because clearly the statute is not speaking to this. And that we reconvene on this matter in November, because as of right now, based on the statutes I'm reading, maybe we need to go to this case and look at this case, and we need to all be educated on this before we make any final orders today. Mr. Casper, what's your thought on that? And you clearly can participate in this conversation with your own case law when it comes back in November. Because as of right now, like I said, I don't think we have a clear answer on this, and I think the case law maybe, hopefully if it's there, will speak to it.
Because I don't want to put you in the box of having to waive certain arguments either that you want to make. So it is your position that deadlock means no action.
Correct.
Correct. All right. And the board is...
To clarify, my position is it takes 5 affirmative votes, as 1A7 says, for any action of the board, especially finding a violation of the election code.
Okay. My concern is I don't want the board, by delaying this, to impact your ability to file any appeal that you think is appropriate, that takes away the time from you to do that. So I don't know if we want to take moments to everyone think about that, or if you know what is in your client's best interest right now, or if you want us to recall the case.
I think that
not to put you on the spot.
I think I want to recall.
Yeah.
So give me a couple minutes.
Absolutely. I think that's fair. So I would move that we...
Wait a minute, Jack, there's already a motion on the floor. Yes.
Oh.
I'm going to withdraw my motion pending this discussion to allow council to take time to think it over. So I'll withdraw my motion at this time.
Thank you.
We just want to be fair. I mean, this is a big deal. And we're all cognizant of that. We're all cognizant based on our vote, what this does. And so we want to give you that.
Yeah, I thought, it never crossed my mind that there'd be a violation. So what do I appeal to the circuit court and say, I'm appealing Mr. Newman's decision, not the board's?
Well, I'm wondering if you...
Is he the defendant or the board?
I mean, is there an appeal on the assessment? Is there an appeal? I don't know. But what I'm saying is we want to give you an opportunity to think about it before, again, I don't want to put you in the trick bag by making a motion that will curtail your rights, even though we ruled the way we did.
Okay. All right, I appreciate that. You give me 10 minutes. I'm sure you got other stuff to talk about.
I move to recall the case at a later time today.
Do we vote on that, Amy?
Today?
We're going to hold about
today. No. Wait.
Yes, today. We'll finish possibly just finish as much of the agenda as we can, and give Mr. Casper an opportunity to think and bring it back when he's ready. Is that a good plan?
Yeah, repeat that, okay, Jack, please, for Amy.
We want to give an opportunity to to just, maybe let's move through as much of the agenda as we can. Give Mr. Casper time to look into what he needs to look into.
Yeah.
Can you
I
not
don't
hear me?
think- Yes, yes, can you hear me?
Yes.
Is that a
Okay.
motion?
Yeah, no, we don't need a motion for that, and Jennifer withdrew hers, so we're fine, and we'll just bring Mr. Casper back at a later date, and we'll continue on with
Not a
appeals.
later date, a later time today.
A later time. Let's just move through the agenda as much as we can, and then Mr. Casper will let us know when he's ready.
Thank you, everyone.
Jordan? Appeals of
Yes.
campaign disclosure?
Appeals of campaign disclosure, where the hearing officer recommended denied. This matter was the only one where I had an appeal. I asked earlier, just confirming that no one has arrived in the interim as on either of these any of these matters.
No.
Great,
No
very
one
good.
here?
The board can, to the extent it wishes, contemplate group motions. However, I would like to take, bear with me here. On agenda item, I'm very sorry, I lost my notes. On agenda items A,
8, 9,
yes.
11, 12, 13, and 14.
Except there are just a few items where it is to modify. Yeah. Okay. Let's just, actually, if you wouldn't mind, can I also, would the board contemplate just a 5-minute break following that matter and to allow me to gather my papers once more? Thank you very much.
Right. Is she ready for it?
There we go.
Yes, we're all
Right now. Cassandra, are you there? There, she's there.
Yes, I am.
All right.
Thank you.
So if we may, before proceeding to, Mr. Casper has returned on matter number 2A10, and as far as what we will consider there, and to answer a couple of the outstanding questions. Typically, this is a matter, frankly, of first impression before the board here, specifically with violations of, or alleged violations of contribution limits. Typically, in the past, the committees who have been assessed similar penalties have simply returned the funds. So, what we have before us is, again, multiple interpretations of the statutory language here. And we also, I have to acknowledge, I am the Deputy General Counsel here. And I will fulfill my responsibilities as the board requests. However, it is also, you have the opportunity today to vote specifically on whether or not to assess the penalties as identified in the assessment letter that is at issue here today. I expect, though, we will then be back in a, if not expect, should we find ourselves in another 4-4 situation, we are right back where we are here now today. And we will be then entering a cycle of 4-4s on what to do. Mr. Casper, not to fully speak for you, but you did state that
I think
it would be okay with you if we also continued.
Thank you very much again, Michael Casper, for the record. I was surprised by this conversation based on the provision that we quoted in 1-A7. So I called up the assessment letter. The reason we're here, the assessment letter says, this is the letter from Mr. Newman, not from the board, from Mr. Newman. And it says, the total fine amount of $9 million, et cetera, will be imposed with the issuance of a final board order, unless an appeal is filed. And we did file timely an appeal, and that's why we're here. So there has been no board order assessing it, according to the letter. And maybe you disagree that the assessment somehow attached even without a final board order, but I'm confident that it takes 5 votes to find the violation, which is what the letter indicated. It didn't say the total amount is owing. It said it will be upon the issuance of a final order. So there are some questions. I agree with Ms. Andrew. There's some questions. I'm happy to come back at the next meeting and sort this out.
I don't interpret Mr. Newman's
Microphone. Use the microphone, please.
Oh, sorry. I don't interpret Mr. Newman's letter the way you do, only because we do final board orders for people who do not appeal. And so that's part of our protocol.
Right.
Regardless of whether it's appealed or not.
Correct, and they don't owe the...
Maybe Deputy General Counsel has a different interpretation.
Yeah, and they don't owe the money until the final board order
Correct.
Correct. And that hasn't happened in this case.
I have a question, please. Jordan, so, I've been thinking about this. So when there's a hearing officer recommendation for an assessment, after that assessment is made, it comes to the board for final vote under assessment. We've never had that here. So there's never been a final board vote under, like today, I mean, what section is that? Here somewhere today it says, yeah, so 2A16 says assessments, board orders. We would vote on that for any assessments that had been recommended by the hearing officer that was not appealed. We haven't done that. We haven't, and we also didn't vote today. So I don't know how this assessment has ever been final, because we usually would vote on that assessment. So that's why I agree. I just don't think there's ever been a final vote on the assessment itself. It always comes to us. Correct?
Yes. Yes, you are correct. Typically speaking, the agenda items that you see that is a motion or that is presented to the board to acknowledge those assessments and issue final board orders thereon. As to this particular matter and the assessments of these fines and the language of the appeal itself, whether or not there has been no final order to assess the penalties at this time. The board can today, now, under a separate motion, contemplate that. Someone can move to assess penalties. Someone can move to not assess penalties. Additionally, we can wait. We can continue this matter to November. We can continue this matter to November 18th. We can call a special meeting of the board sometime between now and then if the board wishes, and we would like to get this matter disposed of then, in contemplation of the possible ripple effects for ballot forfeiture in the event that it is determined that these penalties are assessed. These are all matters that are available, or all options that are available to you now. Unfortunately, I cannot speak to what we have done specifically for violations or alleged, for assessments that have been appealed, assessments under 9-8.5 that have been appealed, because this is a matter of first impression. We have not had this exact experience with these exact type of fines come before the board, nor have we had that come before the board with a 4-4 vote. So those are the options that are before the board today on this matter.
I have a question here from Member Gray.
Jordan, you said we didn't have, I think in the past, in the 37-year history of the state board, there have been 4-4 decisions. Would it
yes,
be?
Member Gray, my apologies. There have certainly been 4-4 decisions, and there is case law with regard to those 4-4 decisions. However, there has not been a 4-4 decision on an appeal of an assessment based out of section 9-8.5 as to whether or not the question is whether or not the contribution limits have indeed been violated. To that level of detail, and not even necessarily with the question that has been presented to the board today, but even simply on an appeal of fines assessed under the board staff process and procedures for acknowledging when the contribution caps lift and return. That in and of itself has not been appealed through an assessment appeal as we have seen today. So the reason why I say that is I can't tell you, oh, we had this back in 2021, this is what happened, XYZ went forward. At this point, for reference, we have the materials before us, which include all of the documentation, including the assessment letter that's a part of this file, as well as the language of the election code. And the board may elect to vote now, as we understand it, on whether or not these penalties should be assessed, or we can do a limited order acknowledging, a limited non-final order acknowledging that the board had a tie vote on the appeal itself, and that the matter of assessing any fines as a result of that inaction or action will be taken up by the board either at the November 18th meeting of the board or by special meeting of the board if you would like to meet earlier than that date. And now, Mr. Kessler.
Yeah, I think that I have no objection to deferring to the next meeting, because I agree that with Ms. Andrew that putting yourselves in a position of this 4-4 vote to accept the hearing officer, to reject the hearing officer, to impose the penalty, to not impose the penalty, presumably results in a 4-4 to impose ballot forfeiture. And so there's, I mean, you know, that seems like a silly cycle to go down. So I think perhaps if Andrew and I can put our heads together and agree upon what the next step should be, whether you take it or not is up to you.
I was just going to say, I think we need a roadmap. We need a roadmap. We need to create a roadmap, basically. Because my concern is if there's no final order, then whatever appeal process you're going to take advantage of is not available to you. But on the flip side of it, we're not going to give you a final order because, as you can see, we're deadlocked. Right. So I think, you know, for everybody to take their time to look at whatever statutory case law roadmap we need to create for this case of first impression would be a good idea.
And if I could add briefly, there have been 2 deadlock votes, I believe, since I've been on the board so far. And every time the general counsel says, because in the event of a deadlock, you pull individual members so that a reviewing court can review the rationale on appeal. And now the premise is that because it's a 4-4 vote, there actually can't be an appeal because there's no final order. So that would go against the premise.
No, I disagree with that.
You disagree with that?
I do.
So
and here's why.
I want you to be able to appeal. That's all I'm trying to do.
And I will appeal an adverse action against my client. Okay. But in the 4-4, the 4-4s you're talking about were electoral board splits where there's a plaintiff, the objector, and a defendant, the candidate. In the event of a 4-4 in that instance, the candidate remains on the ballot. The candidate cannot appeal because they're not aggrieved of your decision. But the plaintiff can because they came to you and said, I'd like an order from you removing this candidate from the ballot, and they didn't get it. So they can appeal in a 4-4. Here, Mr. Newman, for lack of a better way to describe it, is the plaintiff.
Poor Mr. Newman.
Right? He's the plaintiff. And he's seeking an order from you assessing a penalty of $9 million on my client, but he hasn't gotten it. But he can't appeal because the board can't appeal its internal assessments. But if it were some other citizen who filed the complaint and it was 4-4, they could appeal. So that's the analogy that you're thinking.
I think we're going to give you the nickname agency.
Yeah.
So that you're
yeah, right. I hope
being
so.
bantered around. So yeah.
So we can sort this out and come back.
Okay.
So go ahead, Member Watson.
So when we come back,
either in November or for a special meeting. I think the timing
when
is
we come
of
back,
essence.
yeah, right, or in November or for a special meeting, we're going to be discussing whether or not we're going to stay the initiation of any ballot forfeiture action based on any outstanding monies, right? So,
I don't think we
Member
know.
Watson, the question would be whether or not the board will be assessing penalties, and then if penalties are assessed, the action of the board, if any, with regard to ballot forfeiture, if those penalties are, 1, assessed, and B, due and owing at the time at the time is contemplated under Section 9-30.
okay, so 4-4 and 4-4. Now what happens?
Again, this is what we're trying to figure out. And that's why we're trying to take the time to do that, to look at the statute, to look at case law, to hear arguments on it before we come to another vote.
But this is a case of first impression, so you're not going to find case law on point. But the statute clearly says that a final order has to have 5 votes. So the question really is, in the absence of 5 votes, you want a roadmap. But that is the roadmap. You need 5 votes for this board to do anything. because that's the law. And if we stay at 4-4, we never have 5 votes. Therefore, this board cannot issue any kind of order, and Mr. Newman cannot possess the authority from the board because the board will not have given any authority in a final order. So it should be over with, is my point.
I agree. Well,
I don't think that it's over if we can't decide whether or not to assess fines. And I think that's the question, and that's what I would like for myself. And maybe you feel differently, Member Watson, but for myself, I'd like some more information before I make that decision.
Okay, what kind of information are you looking for?
I will decide that when I find the information that I'm looking for. Or when I'm given that communication by our Deputy General Counsel or our General Counsel.
If I may, I believe, if I'm hearing everything, that Mr. Casper and and Jordan are in agreement on next steps on collaborating together and coming up with perhaps a joint recommendation or a roadmap, whatever it is, and we'll let you figure out what's best for the parties, for the board, for recognizing that there is a deadlock and it's a 4-4 vote. Give us a menu of options and let the board decide at a later date. That right now, it seems to me, everyone is focusing on process instead of the substance. We all agree that we want to protect the rights of the committee. We want Mr. Casper to fully avail himself of all the rights he has to appeal this, and we also want to recognize that that there is a deadlock, and we probably will not reach an agreement on process. So let's come up with a roadmap for them to move it on to the next level, whatever that is.
Yeah, so I think that's just a motion to recess till the next meeting? Agreed.
Well,
I therefore move to
we have to have a motion from the board, Mr. Casper.
I therefore move.
I wasn't making a motion, I was just paraphrasing it.
Right. I therefore move to recess this matter for the next meeting of the board.
I second that motion.
it's been moved and seconded to recess this, continue to the next meeting in November. Amy, roll call, please.
Ms. Bellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Durbin?
Yes.
Chair Donahue?
Yes.
And motion passes.
Thank you for your time, everyone.
Thank you, Mr. Casper.
Thank you. And I have organized, I've reorganized my notes under the break, and I appreciate the board's leave and patience with me to do that. I am ready when the board is to proceed to the next section, which are appeals of campaign disclosure fines, where the hearing officer recommendation is to deny the appeal.
Continue, Jordan.
Very good.
Do you want to do them jointly or separately, or how do you want to proceed with them?
A little bit of both, if you don't mind. I would first like to do a group motion on agenda items 2A8, 2A11, and 2A14, where the hearing officer recommendation was to deny the appeal, and I concur in that recommendation.
Do I have a motion on 2A8, 2A11, and 2A14 to deny the recommendation?
So moved.
Second? Do I have a second?
A second.
And just as a clarification, Chair, was the motion to deny the appeal or to deny the recommendation? Because the recommendation was to deny the appeal.
To deny the appeal.
Yes.
So the motion is moved and seconded. Amy, roll call.
Ms. Bellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Durbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Jordan?
The next matter would be agenda item number 9, which is the SBE versus the Illinois Beverage Association PAC. Here, the hearing officer, the committee appeals the assessment of civil penalties assessed for the delinquent filing of 5 Schedule A1 reports, the committee's 5th through 9th violations, as detailed here. First was a $4,056 contribution filed 46 days late with a penalty of $3,000 assessed. Second was a $1,263 contribution filed 42 days late with a penalty assessed of $1,263. Third was a contribution of $2,753 filed 25 days late with a $2,753 penalty assessed. Fourth was a $10,896 contribution filed 12 days late with a penalty of $1,800 assessed. And finally, a contribution of $1,998 filed 12 days late, also with a penalty of $1,800 assessed. The total penalties assessed here is $10,616. In the appeal affidavit, the committee's treasurer explains that she didn't realize the A1 reports didn't automatically generate and file when the contributions were reported on the quarterly reports, and she didn't realize that she was supposed to list the deposit date of the contribution, not the check date. The hearing officer recommends, and I generally concur, that the appeal be denied for lack of a statutory basis to waive all of the fines. However, the information provided by the committee in its appeal affidavit does indicate that the delinquency dates for some of the contributions should be reduced based on the properly reported deposit date. Specifically, contributions 1 and 2 should both be reduced to 38 days late, but this does not change the penalty assessed because they were still more than 20 days late. Contribution 3 should be reduced to being 16 days late, which results in a $353 penalty reduction, and no change for contributions 4 and 5. So therefore, my recommendation is to deny the appeal as to contributions 1, 2, 4, and 5, and insofar as the appeal results in the reduction of the civil penalty associated with contribution 3, reduces the total fines assessed by $353, I recommend to modify the recommendation of the hearing officer to grant the appeal in part and deny it in part.
Do I have a motion?
I have a question first.
Question?
I'm sorry.
Member Craig?
I just saw in the paperwork, they have offered a settlement. Are they going to come next month, or will we take this up after we take this vote?
I was intending to present the settlement offer after the board voted on the appeal. So immediately following the vote.
All right. Do I have a motion?
I move to accept the recommendation of the general counsel and accept the hearing officers as modified by the general counsel.
Is it second? Seconded, Jennifer? Roll call, right?
Ms. Bellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Did you say no?
Yes.
Yes.
Sorry, I'm so sorry. Could you repeat that with the microphone, please?
Yes.
All right, thank you. It sounded like a no to me.
It did sound like a no.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Jordan?
Thank you. As Member Cray noticed up, with its appeal, the committee here did submit a settlement offer in the event that the appeal was denied. Here, they have offered to settle the $10,263 for $5,838.80. This offer does exceed the 50% threshold of the recalculated fine amount, and it does meet the preferred receipts ratio. However, the balance ratio, the preferred balance ratio, does fall short, and the committee is not low dollar. Because it is short on the receipts ratio and not a low dollar committee, I do recommend that the settlement offer be rejected.
Discussion? Question? Motion?
Make a motion to accept the recommendation of the Deputy General Counsel. And the hearing officer. And reject the
Settlement offer.
excuse me, and having small.
It's been moved and seconded. Amy, roll call?
Ms. Bellicroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
And Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Durbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right.
Okay, thank you. The next matter up for consideration is agenda item 2A12. And here, my recommendation is similar to the one that followed, where I concur with the hearing officer to deny the appeal, except insofar as information gleaned from the appeal affidavit results in a reduction of the penalties assessed. And here, that reduction would be a $375 reduction. So I do recommend to grant the appeal in part and deny the appeal in part.
Do I have a motion?
I have one comment, please. Mr. Newman, I noticed that the person that filed for both number 9 and number 12 are the same person, Talia. Perhaps we could recommend to her to take one of our classes. Just so we don't see her again.
I'll be happy to let her know.
Thank you.
All right, do I have a motion to accept the recommendations of our deputy counsel?
So move to recommend deny in part and grant the appeal in part.
Second.
It's been moved and seconded. Amy?
Ms. Bellicroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Durbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
And similar to the matter that we just considered, this committee also submitted a settlement offer in the event the appeal was denied. Here, the committee is offering $825 to settle the $1,125 penalties assessed. The committee meets the balance ratio, falls short of the receipts ratio, but the offer exceeds the 50% threshold, and this committee is low dollar. So because of those reasons, I recommend that the settlement offer be accepted.
So moved.
Second.
It's been moved and seconded.
Ready?
Yes.
Ms. Bellicroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Durbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Next up would be agenda item number 2A13, SBE versus Asif Malik. Here, very similarly, the committee is appealing the assessment of $1,780 in civil penalties resulting from the delinquent filing of 4 Schedule A1 reports. In its appeal affidavit, the committee did not offer a statutory basis to acknowledge that the appeals themselves were assessed in error. However, they did offer evidence identifying that the delinquency dates should be adjusted. Specifically, that the delinquency dates with regard to 2 of the contributions would be reduced, resulting in a $120 reduction of the civil penalties assessed. For this reason, I recommend that the recommendation of the hearing officer to deny the appeal be modified slightly insofar as the penalty amounts are reduced and to grant in part and deny in part.
Do we have a motion?
So moved. To accept the recommendation of the Deputy General Counsel.
And it's been moved and seconded. Amy, roll call, please.
Ms. Bellicroft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Appeals of campaign disclosure fines. Jordan?
Yes. Okay. Finally, agenda item number 15, SBE versus Friends of Ron Gardner. The committee is appealing the assessment of $1,800 in civil penalties resulting from the delinquent filing of 3 Schedule A1 reports. A $1,000 contribution from Calumet City Plumbing filed 5 days late with a penalty of $750 assessed. A $1,000 contribution from Gallagher Asphalt filed 5 days late with a penalty of $750 assessed, and a $2,000 contribution from Bevdas filed 2 days late with a penalty of $300 assessed. In the committee's appeal affidavit, the committee's treasurer stated that he mistakenly dated the reports with the check dates, not the deposit dates. However, documentation provided along with the appeal affidavit show that while 2 of the contributions at issue should be reduced based on the corrected deposit dates, the A1s themselves were still delinquent. The hearing officer recommends, and I generally agree, that the appeal be denied because the committee has not established a statutory basis that the penalties were assessed in error. However, insofar as the committee has offered evidence to reduce the delinquency dates and that reduction results in a penalty reduction of $300, I recommend that the appeal be denied in part and granted in part. In addition, board records indicate that the committee has not amended the relevant quarterly reports to reflect the correct deposit date. So I also recommend, along with the hearing officer, that the committee be ordered to amend its March 2025 quarterly reports to reflect the correct deposit date for the contributions at issue.
Do I have a motion?
A motion to, go ahead.
General Counsel?
Is there a second?
Second.
It's been moved and seconded. Amy?
Ms. Ballard-Croft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right. We have other campaign disclosure items. Board assessments are in your packet. Jordan?
Yes, that is correct. This is a listing of assessments which necessitate a final order for those penalties to be assessed. Those assessments appear on pages 237 through 240 of your packet. And I would need a motion from the board to assess, to issue a final order on those assessments.
So moved.
I can't hear.
It's been moved by Chris and seconded by Catherine.
Okay.
Roll call, please.
Ms. Ballard-Croft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
No.
Vice Chair Turbin?
No.
Chair Donahue?
Yes.
Motion passes.
2A17. Any discussion on that, Jordan?
I do not believe so, no. It's for informational.
Informational, all right. We will go into closed session for complaints.
Here we would need a motion to go into executive session to consider complaints following closed preliminary hearing conducted in executive session pursuant to section 9-21 of the election code, as well as sections 10 ILCS 5/9-21 and section 2 C4 of the Open Meetings Act.
Do I have a motion to that effect?
So moved.
Second? Second. Moved and seconded. Amy, roll call.
Ms. Ballard Croft?
Yes.
Ms. Cray?
Yes.
Mr. Nevesi?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.